The International Criminal Court is now in session.
Welcome to both teams, the prosecution and the defense team for Lord Blaze. I welcome you to this last 16 round. Perhaps we shall begin with the taking of appearances. So if the team for the prosecution could just inform us of who they are and how they will be splitting their time.
My name is Bilal Qureshi on behalf of the prosecution, and I will be speaking for 25 minutes.
Thank you very much. And so I assume then that you have reserved 5 minutes then for rebuttal.
5 minutes, yes.
Right. Could counsel for Lord Blaze introduce themselves and tell us how they intend to split their time?
Good morning, Mr. President, Your Honors. My name is Yinan Zhou, and my co-counsel's name is Elena Hendrick, and we are presenting the defense. And I will address the first issue about jurisdiction for about 10 minutes, and my co-counsel will address the last 3 issues for about 15 minutes. Thank you, Your Honors.
Thank you very much, Counselor. So now I will give the floor to the prosecution. Mr. Bilal, you have the floor.
Mr. President, Your Excellencies, and may it please the court. I am Bilal Qureshi, and today I shall be representing the prosecution in the case concerning the enslavement of 30,000 individuals belonging to Black Mound, a province of Earth Nation, who were arrested and detained at different times and different days. Over the course of the next 25 minutes, the prosecution will make 4 submissions. First, that this court has subject matter jurisdiction. Second, that this case is admissible pursuant to Article 17(1)(c) of the Rome Statute, and the amnesty granted to the President cannot be invoked before this court. Third, the pursuance of this case would be in the interest of justice. And lastly, that there are reasonable grounds to believe that Lord Blaze is criminally responsible pursuant to Article 28(b) of the Rome Statute. On the first issue of jurisdiction, the prosecution makes 2 submissions. Firstly, that the legal test of enslavement is made out, and secondly, that the people of Black Mound were discriminated against and were subject to a systematic attack. The ICTY Appeals Chamber in Prosecutor versus Konarik on paragraph 542 stated that indications of enslavement include elements of control and ownership, that being the restriction or control of an individual's autonomy, freedom of choice, or freedom of movement, and the accruing of some gain to the perpetrator. A further indication of enslavement would also include the exaction of forced or compulsory labor, often without payment. In regards to the element of gain, Your Excellencies, the prosecution submits that Fire Republic had very specific reasons to carry out the crime of enslavement in particular. Those reasons being, firstly, Fire Republic's economy is based on coal mining and metalwork. When detainees were forced to work within the detention centers, the work in question involved mechanics and other trades, as stated on paragraph 9 of the case facts. Now, the defense may claim that these individuals were taught these skills in preparation for their reintegration into society. However, Your Excellencies, it is highly questionable that earthbowers belonging to Black Mound are being taught skills that are predominantly applicable in Fire Republic. Fire Republic had also confiscated the passports of these detainees upon their arrival at the detention centers, and these passports were not returned upon release,
Counselor,
as evident from paragraph 13 of the case facts, which only indicates that these individuals are forced to remain within Black Mound.
Counsel?
In furtherance to this, in Prosecutor versus Konarik on paragraph 575,
Counsel.
the appeal...
Counsel, can you hear me?
Yes, yeah. Yes,
So
Mr. President.
So you said it is highly improbable that they're being taught these skills. Is that the test that this court has to apply?
Yes, Your Excellency. Pursuant to Prosecutor versus Konarik, forced labor stands to be but one factor of enslavement. However, the ICTY jurisprudence has previously in a number of cases set out many further indications of enslavement, which also include restrictions on an individual's autonomy and their freedom of movement and freedom of choice.
Yes, I guess my question is more about the standard of evidence, shall we say?
Fire Republic had also confiscated. My apologies, Your Excellency.
Yes. So I guess my question is,
audible.
or am I not audible? Right. So I guess my question is
I
about.
can hear you, yeah.
So I guess my question is about the point that you made, that it's highly probable, and I'm asking, is that the standard? This high probability, is that the standard that we are to apply?
Yes, Your Excellency.
And on what basis is that the standard?
In Prosecutor versus Konarik, as stated on paragraph 575. However, Mr. President, this standard is not the only sole determining factor that these individuals were subject to enslavement. If one were to see Prosecutor versus Konarik on paragraph 575, the appeals chamber also noted that the Muslim civilians held at the various schools served no less than detention centers at the relevant time, for the simple reason that the detainees were kept in unhygienic conditions. They were provided with insufficient food. Their freedom of movement was curtailed. They were guarded, and they also lived in an atmosphere of constant intimidation. Similarly, in the case before us, Your Excellencies, the detainees were made to work 7 days a week for 12 hours each day with only one 30-minute lunch break in between. They were also forced to stand outside in the snow and bow down in front of a picture of the president as a punishment for either refusing to work or being too weak to continue to work, all while the BNS officers witnessed these occurrences. These detainees have been deprived of their right to live according to their own independence due to the restriction on their individual autonomy, and have constantly existed in an atmosphere of subjugation and intimidation. Having established the legal test for enslavement, the prosecution would now proceed to submit that this case falls within this court's jurisdiction pursuant to Article 7.1 of the Rome Statute, which sets out the legal test that in order to qualify as a crime against humanity, the acts must be part of a widespread or systematic attack directed against any civilian population. The ICC...
Counsel, so may I just take you back to the first leg? Do we have sufficient evidence for the allegations that you make to proceed?
Yes, Mr. President. We rely on Haurock's statement as evident from paragraph 12 of the case facts, one of the escaped detainees who has witnessed this, the treatment in question.
Right, and that's really then the problem, right? That we only have this one witness.
Yes, Your Excellency. However, as the ICTY jurisprudence has held previously in the case of Prosecutor versus Celebici appeal judgment on paragraph 506, there is no legal requirement that the testimony of a single witness on a material fact be corroborated before it can be accepted by this court as evidence. What matters here is the reliability and credibility of the testimony. And the prosecution in this regard does submit that Haurock's statement regarding the events within the detention center has extreme probative value to this case at hand, and making the only available eyewitness and victim testimony inadmissible would increase this court's chances of allowing a crime to go unpunished, leading to further impunity.
One last question on this. I promise I won't ask you another question on this. Why is he the only available witness? I mean, there were so many other people detained who've now been freed. Why aren't they coming forward?
Yes, Mr. President. On that point, the prosecution would submit as evident from paragraph 22 of the case facts. Upon release, these detainees, the first instinct in their mind after being released from the detention centers was to flee from Fire Republic to the neighboring country of Water Kingdom, which only speaks for the trauma and abuse that these detainees have been through within the detention centers. And in addition to that, these detainees were also deprived of with establishing that a crime against humanity has occurred as part of a systematic attack directed against any civilian population. As this court has previously stated in Prosecutor versus Mathura, Kenyatta, and Ali on paragraph 110, that the qualifier any civilian population has been previously interpreted by this court to mean groups that are distinguishable by nationality, ethnicity, and other distinguishing features. In the case before us today, Your Excellencies, all 40,000 individuals arrested between December 12th and 14, 2018 belong to the Earthbower community of Black Mound, therefore qualifying as a group distinguishable by nationality and ethnicity compared to the rest of the population in Fire Republic. Additionally, jurisprudence such as the ICTY case of Prosecutor versus Kodich on paragraph 96 have shown that the phrase directed against denotes that the civilian population was subject to an attack in the context of a crime against humanity. A point of utmost importance, Your Excellencies, is that all ANG leaders were given the title of terrorists, which according to the United Nations Security Council Resolution 1566 is a term applied to any individual committing criminal acts with the intention to cause death or bodily harm with the purpose of provoking terror in the general public. The prosecution in this regard submits that such a heinous label was applied not only to the ANG leaders, but to the entire Earthbower community of Black Mound, as Exhibit 1 clearly shows, Ms. Ursa expressly stating that all 40,000 individuals have been sent to detention. The topic of this conversation, Your Excellencies, was the 40,000 individuals arrested between December 12th and 14, 2018. These individuals...
Counsel, there's a little gap there. So you're saying that this label was applied to the whole population, but it's not clear to me why you use on what basis that is.
Yes, Mr. President. Evident from Exhibit 1, which is the telephone conversation obtained between the President and the Minister of Interior, they discussed that all 40,000 terrorists have been sent to Center Rig. And the subject of this conversation was the 40,000 individuals arrested between December 12th and 14th.
So all that says is that they assume that these 40,000 are terrorists, not necessarily the whole population. And yet the argument that you're making is that this label was bestowed on the whole population, no?
Yes, Your Excellency.
So that's the gap I'm talking about.
What the prosecution means to submit is the civilian population in question, which concerns the arrest. The civilian population in question, which concerns the 40,000 individuals that were arrested. These people, Your Excellencies, were arrested for commemorating the 1450 Earthbower lives lost during the summer clashes, which only shows that it failed to matter whether or not Earthbowers were actually committing terrorist-like activities during that time, and such a label was associated with their name on discriminatory grounds. The prosecution therefore requests the defense counsel to explain why such an extensive number of people, all belonging to the same minority, was so casually referred to such a serious charge in the absence of any terrorist-like activities on part of Earthbowers during the time of these arrests. Next, we also submit that this attack was systematic in nature. According to ICTY Prosecutor versus Kodich on paragraph 94, the term systematic refers to the organized nature of the crimes and the non-accidental repetition of similar criminal conduct. Your Excellencies, the organized nature of this crime is clear, and this clarity is present as a result of the extreme attempts to assert dominance and control over the Earthbower population in Black Mound. For starters, in 2015, Fire Republic, led by Lord Blaze, appointed a Ding leader to Black Mound, under whose leadership all Earthbower rituals were prohibited, and violations of basic human rights were so severe that not only adults, but also Earthbower children were barred from speaking their own native language. This mistreatment went to an extent, Your Excellencies, that Earthbowers were not allowed to practice their religious rituals or speak their language, even within the confines of the detention centers. Furthermore, the arrest of 40,000 individuals over the span of only 2 days in itself speaks for the systematic and organized nature of these crimes. What we're seeing here, Your Excellencies, is a pattern. Between the summer of 2018 and December of 2018, Earthbowers have been arrested and detained on multiple occasions, sent to detention centers, and labeled as terrorists. This merely indicates that over the course of 7 months, mass arrests targeting the Earthbower population have occurred with no explanation given as to why.
Can the explanation be that this is a state that is under attack? Can the explanation be that this is a state that is under attack, and so it wishes to protect
no,
its
Your
territorial
Excellency,
integrity?
however, as one Yes, Your Excellency. However, this is what we're witnessing is a battle between a state and a province, as it is on the merits of the facts of the case, the state of Fire Republic against the province of Black Mound, therefore pointing to a clear imbalance of power in that regard as it is. In regards to the admissibility of this case, the prosecution makes two further submissions. First, that Lord Blaze has not been tried for the same conduct on the national level pursuant to Article 17(1)(c) of the Rome Statute. And second, that amnesties cannot be granted for crimes against humanity in general and specifically not for Lord Blaze. To begin, it should be noted that while Lord Blaze's amnesty has been confirmed by the judge, this case strictly concerns the crimes against humanity of enslavement under Article 7(1)(c) of the Rome Statute. In ICC Prosecutor versus Lubanga, despite the fact that the suspect was under national investigations for the serious charges against him, the case against him was still deemed admissible before this court because those specific charges were not investigated domestically for the same conducts being investigated by the prosecutor. The prosecution submits that the amnesty granted to Lord Blaze has made no mentions of crimes against humanity of enslavement, implying that the national proceedings against the president do not involve the conduct at issue, which is the critical subject of the case today. Additionally, Your Excellencies, the prosecution also submits that this amnesty should not be granted to the president simply because of the Rome Statute's preamble suggestion that deferring a prosecution due to the existence of a national amnesty would be incompatible with the court's purpose, which is to ensure criminal prosecution of those who commit serious international crimes.
Where does the Rome Statute say that?
In the Rome Statute's preamble suggestion, yeah.
Okay, where does the Rome Statute preamble say that prosecution or that giving amnesty would be contrary to its purpose? Because that's what you said.
Yes, Article 7 of the Rome Statute's preamble suggestion.
Article 7 talks about amnesty.
There is a mention, Your Excellency, as this court has also stated in the ICC case of Prosecutor versus Gaddafi in relation to this point, that there is a strong universal tendency that grave and systematic human rights violations, which may amount to crimes against humanity by their very nature, are not subject to amnesties under international law.
Okay, we'll get to that. But my question for the moment is, where does the Rome Statute say that? Is there a place? If you can't find it, it's okay. We can come back to it.
Yes, Your Excellency.
Okay, proceed. Okay, proceed.
In addition to this, international tribunals have also revealed their position with respect to the prohibition of amnesties for international crimes. One such example would be the massacres case, in which the Inter-American Court of Human Rights expressed its disapproval of amnesty laws in general, when it recognized on paragraph 283 that amnesties or similar mechanisms have been one of the obstacles cited by states in order to comply with their obligation to investigate, prosecute, and punish those responsible for grave human rights violations. Additionally, Your Excellencies, amnesty is frequently linked to accountability mechanisms. For example, in the situation in Haiti, the accused was granted amnesty. However, such was only done so on the condition that they relinquish power and allow the democratically elected civilian president to return. In the case before us today, while Law Number 14, Article 3, has established accountability measures for ANG members, no accountability measures were established for Fire Republic state officials or agents. Even in the president's apology to the victims, Lord Blaze has failed to take responsibility for his own actions, instead blaming Ms. Ursa and the BNS for the crimes committed. However, the most important factor here, Your Excellency, is the absence of the relinquishment of power. Lord Blaze still stands as president of Fire Republic today, whereas the Minister of Interior still holds her effective position. If this court were to look at the situation in Black Mound prior to and after the amnesty that has been granted, there is simply no difference. This brings counsel to our third submission, that pursuant to Article 53(2)(c) of the Rome Statute, the prosecution submits that the pursuance of this case would serve the interests of justice, as this case is of sufficient gravity and its pursuance is also in the interest of victims. The defense would argue, Your Excellencies, that pursuing this case would not serve the interests of justice because it would destabilize the now established peace. The prosecution in this regard simply submits that given the lack of accountability mechanisms and the lack of difference this amnesty has made for the victims of this heinous treatment, the defense's piece is rather built on a bubble that is waiting to burst. Although we acknowledge that the detention centers have now been closed and all detainees have been released, this does not change the nature of the crimes that have been committed. In assessing the gravity of the case, the pretrial chamber 2 in ICC situation in Kenya on paragraph 62 underlines several factors to assess gravity, including the scale of the crimes, the manner of commission, and the impact these crimes have had on the victims and their families. As per this court's policy paper on preliminary examinations 2013, the manner in which these crimes were committed may be evaluated in light of the extent.
Whose policy paper?
The International Criminal Court's policy paper.
That we drafted?
Yes, Your Excellency.
Don't think so, but okay.
The crimes were systematic and included elements of particular cruelty, such as victim vulnerability and any motives involving discrimination as a means of destroying groups. The prosecution submits, Your Excellencies, that these victims were vulnerable in the eyes of Fire Republic officials due to an obvious imbalance of power, as Agent has previously stated, that has allowed Fire Republic to oppress these individuals repeatedly. In the interest of time, Your Excellencies, I will quickly summarize my last submission regarding criminal responsibility pursuant to Article 28B of the Rome Statute. In this regard, Your Excellencies, the prosecution makes three submissions. Firstly, that Lord Blaze consciously disregarded information indicating that the crimes were or were about to be committed. Second, that there was a failure to exercise control effectively. And lastly, that he failed to exercise all reasonable and necessary measures to prevent the commission of these crimes. Exhibit 1 shows, Your Excellencies, that Lord Blaze himself orders the release of detainees in Center Lotus, demonstrating that he was involved in the operations and decision-making regarding the detention centers. It is rather absurd to claim that an individual who was himself ordering the release of detainees from within the detention centers had no idea what was actually happening within these facilities. Similarly, in the ICTR case of prosecutor versus Nirma Suhuko on paragraph 5807, given the control the accused possessed over the policemen and the fact that the accused maintained regular contact with these officers, the chamber in that case did not accept the claim that he was unaware of any police involvement in an attack which was systematic and large-scale in nature. In our case, Your Excellencies, Lord Blaze not only maintained contact with the Minister of Interior, but also participated in the operations of the detention centers and authorized materials that were then supplied to these facilities.
Final question from my side. So is the difference between that case and this case that the connection between the operators is one person far removed? And so between the operators of the prison and the president, you also have the Minister for Interior. Does that not somehow play into this, that it's then possible that his knowledge may be have been limited?
Yes, Your Excellency. However, on that point, Council would also point to the fact that these detention centers were made only 2 days after an anti-executive order given to the Minister of Interior from the President, requesting her to use all means necessary to end potential threats to national security. And there was also a failure from the President's part to follow up on an order that did concern national security. And additionally to that point, Your Excellency, to further answer your question, Lord Blaze was, the prosecution admits, given the opportunity to learn what the detainees were up to within these detention centers. And we do understand that this message was not conveyed due to a disturbance in the phone call, as evident from Exhibit 1. However, the prosecution in this regard also submits that this too points towards a failure to exercise that control properly, as the President has not made any efforts to follow up on such information. Lastly, Your Excellencies, the Appeals Chamber in Prosecutor versus Halalovich on paragraph 63 outlined that reasonable measures are those that are reasonably falling within the material powers of the superior, whereas necessary measures are those that stem from his position of authority and are measures appropriate for the superior to discharge his obligations. The suitable actions to contain the situation in our case, also quoted by the ICTY in Prosecutor versus Radovan on paragraph 588, would be to carry out an effective investigation to establish what was actually happening within the detention centers, to make further inquiries, to take measures against the commission of the crime, such as, for example, demoting Ms. Ursa from her position as Minister Interior, and also offering compensation to the detainees as per Rule 116 of the United Nations Standard Minimum Rules for the Treatment of Prisoners. However, Your Excellencies, no such measures were taken by Lord Blaze, despite being a figure in utmost control and authority. Therefore, the prosecution in this regard does submit that there was a failure to take any necessary and reasonable measures to prevent the commission of crimes. I see that my time is almost expired, Your Excellencies. In light of these submissions and the compelling facts at hand, the prosecution urges this court to determine that the charges against the suspect be confirmed and this case be allowed to proceed to trial. May it please the court.
Yes, thank you very much, counsel. Counsel for the defense, you have the floor.
Thank you, Your Honors. The defense requests the court to decline the charges made against Mr. Lord Blaze, and we will show that there is no reasonable ground for the case to proceed, and we made 4 submissions. First, the court has no subject matter jurisdiction over the case, since neither the contextual nor the specific element of crime against the humanity of enslavement have been fulfilled. Second, the case is inadmissible, as Mr. Blaze has already stood trial for the same conduct before a domestic court, and the purpose of these proceedings was not to shield him from a criminal responsibility. Third, the case was not serving the interests of justice, as it would destabilize the peace process. And lastly, there is no reasonable ground to believe that Mr. Blaze is criminally responsible for the alleged crime. I will address the first issue about jurisdiction, while my co-counsel will address the last 3 issues. On the first issue of jurisdiction, we submit that the court has no subjective matter jurisdiction over the case, since neither the contextual element of crime against the humanity nor the specific element of enslavement have been fulfilled. First, we submit that there is no reasonable ground to believe that the contextual element is satisfied, since there was no attack directed against the civilian population, and there was no such a state policy to commit such an attack. Attack, pursuant to Article 7, Paragraph 2A Rome Statute, consists of a course of conduct involving the multiple commissions of acts referred to in Article 7, Paragraph 1 Rome Statute, and against any civilian population. And in Contenga Trial Chamber, it's noted that the requirement of directed against means that the civilian population must be the primary object of the attack, not just an incidental victim. In our case, since 2015, the Black Moot was under Ding's leadership, and we cannot deny that between 2015 and September 2018, the Ding government tried to restrict the behavior of the Earth Powers to gain control over Black Moot and end its semi-autonomous status. However, the means and method taken by Ding didn't belong to any of the acts referred to Article 7, Paragraph 1 Rome Statute. During summer 2018, with the government crackdown intensified, a large number of ANG loyalists were arrested. However, at that time, there were frequent and violent non-international armed conflicts between ANG and the Fire Republic. ANG is a resistance group and an organized armed force, according to Article 43, Additional Protocol 1 of Geneva Conventions.
Counsel, may I just ask you a question? So the decision and the policy to discriminate against the Earth Powers, to prevent them from speaking their language, to prevent them from practicing their culture, is this all directed? Is this not directed at a civilian population? Is this not part of the widespread attack?
Yes, thank you, Your Honor. Thank you for the question. We will say that crime against humanity, according to Article 7 Rome Statute, is an atrocity crime, and what the means and methods taken by Ding must have the same gravity and the same nature as the acts referred to Article 7, Paragraph 1A to K Rome Statute, such as torture, murder, sex slavery, and rape, etc. Based on case fact 4 and 5, what Ding government did through the forbidden their speaking their language and forbidden the ceremony out of the security reasons, is to gain control over the black mount. And we must admit that it's not an appropriate method to gain control over the black mount, but it's not the acts of Article 7, Paragraph 1 Roma Statute. And besides, we submit that the intention of the Ding government is to gain control over black mount, not to cause the physical or mental suffering to Earth powers. So we will see that, we submit that the means and method taken by Ding didn't belong to any of the acts of Article 7, Paragraph 1 Roma Statute. I hope you're satisfied with my answer, and if I may proceed.
If I don't say anything, it means that you may proceed.
Yeah, thank you, Honor. And during summer 2018, with the government crackdown intensified, a large number of ANG loyalists were arrested. But at that time, there were frequent violent non-international armed conflicts between ANG and the Far Republic, as I already addressed. And ANG is the resistance group and organize the armed forces according to Article 43, Additional Protocol 1 of Geneva Conventions, and therefore their members are combatants, are non-civilians according to Article 50, Additional Protocol 1 of Geneva Conventions, which means that they were not protected by Article 7 Rome Statute. And since 21st September 2018, the BNS was ordered by President Mr. Lord Blaze to monitor the situation in Blackmount. And on this point, we submit that there are no such a state policy to commit such an attack. Pursuant to Article 7, Elements of Crime, Introduction, Paragraph 3, the state policy to commit such an attack requires that a state must actively promote or encourage such an attack directed against the civilian population. But by reading the case factor 7, the anti-extremism executive order, we can see that the tasks of BNS ordered by President Mr. Lord Blaze was to monitor the situation in Blackmount and end the potential threats to national security. Who are the potential threats to national security? Who is the extremism that the Far Republic really against? It's not the civilian population, it's not the Earth powers who live peacefully and normally in Blackmount, but the resistance group ANG and their members who are not civilians.
Just back to my question then, and I won't ask the question again. So what does this have to do with so the freedom of expression, the right to culture that's been taken away from the people? It hasn't been taken away from the movement only, it's been taken away from the whole population, right? The Earthbound population, is that not correct?
Sorry,
these discriminatory practices that are part of a policy, are they not directed at the whole Earthbound population?
Thank you, Owner. We will say that the state policy disorder by President Mr. Blaze on 21st, signed on 21st September was not against the civilian population, was not against the Earth powers, but against the threats, the potential threats to the national security. And this potential threats is ANG members. Is since there was a frequent and violent non-international armed conflicts, at that time the president signed these orders to monitor the situation in Blackmount.
Final question. So it is then your submission that all the other Earth powers were entitled to engage in their culture, to speak their language. That's now your proposition.
No, we submitted and we insist that the order is against the ANG members, not the Earth powers. And yes, if I may proceed. All the measures undertaken by BNS, including opening the educational centers and sending the terrorists to take part in the free educational programs in there, focused on these non-civilians and aim to curtail the resistance of ANG and give the peace back to Blackmount. Thus, this order is not such a state policy to commit such an attack directed against the civilian population, since neither the primary objective, the primary purpose, nor the intention of this order is against the civilian population. And Besides, there was no accurate data to show that how many of the arrested and detained are civilians.
So, Councillor, now I understand your argument. So your argument is, well, it may have affected the population, but because they were not the primary targets and it was not the intention, then it's okay.
Oh,
is that the argument?
That is okay, but we said that the state policy, we see that the orders was not against the civilian population, but against the ANG members.
So even if it affects them, not just incidentally, because this was not just an incidental effect. I mean, it concerned them. That takes it outside of the scope of the chapeau of Article 7.
We would submit that a crime against humanity consists of objective and subjective elements, and since the subjective elements is not fulfilled here, so we submit that crime against humanity is not fulfilled. If I may proceed. Thank you. And as I said that there is no accurate data to prove that how many of the detained and arrested are civilians. And in contender trial chamber, it's noted that the civilian population compromises all persons who are civilians as opposite to the members of armed forces and other legitimate combatants. And in Nicholas Sandwich case, that in order to determine whether a population is civilian, the civilian status of the victims, the numbers and the proportions of the civilians within the population must be evaluated. However, in our case, neither the numbers nor the proportions of the civilians within the detained earthbowers can be determined. Accordingly, we submit that the attack cannot securely be said to have targeted a predominantly civilian population. And second, we submit that there are no reasonable grounds to believe that the specific element of enslavement has been fulfilled according to Article 7, Paragraph 1C Rome Statute, because there was no exercising of any or all of the powers attaching to the right of ownership over a person. The unsatisfactory conditions as centric claimed by Harry Rock, which prima facie meet some of the counter factors. However, whether enslavement has occurred or not is a matter of factual determination. The subjective belief that slavery has occurred, even by former inmates, is legally irrelevant. And the essence of the enslavement is not an assessment of the state of the detention, but the analysis of whether human beings were placed into a state of being owned or commodified. It was pointed out in Kangeki Avi case that in going through the checklist of indicia of enslavement, the chamber must above all identify the indicia of ownership, which is the victim being reduced as a commodity, such that he or she can be used, economically exploited, consumed, etc., or as an object of enjoyment of possession. However, there is no enslavement, where the primary objective of the detention was not to exercising of the right of ownership. In our case at Century, the overt aim of the detention was all the time the re-establishment of the public order and security at Blackmount, instead of pursuing economic benefits from these earthbowers working or making them as an enjoyment of possessions. And moreover, in Paul case, the core of enslavement has been established as involuntary servitude rather than mistreatment. Also, in Conrad case, consent may be evidentially relevant to the question of whether the exercising the power attaching to the right of ownership over a person has been established or not. Accordingly, the right of ownership over a person shall be interpreted in light of the freedom of the choice of the victim, rather than the formal control of the power of the agent. The arrested earthbowers had freedom to choice. They could choose to go to the educational camps, and in exchange, their detention was reduced by 2 months as a remuneration. And it's worth noting that the exaction of forced labors, often without remuneration, referred in Conrad case. Or if they declined to participate in the free educational programs in there, they would be sent to the prison and to be held as a normal prisoner until the end of their sentence. Thus, there is no lack of consent, and the consent of the detainees can be evidentially relevant to deny the establishment of the element. exercising of the right of ownership.
Where is this consent? Sorry, I missed it. I think I may have missed it when you were explaining the consent. Where do we see, what's the evidence for this consent?
Based on the case fact, if I didn't remember wrong, is based on the case fact 9, that according to the release press of the Ministry of Interior, that the Earth Powers is voluntary to participate in the educational camps in the century. And they had freedom to choose to go to the educational camps or go to the prison. If I may proceed. Thank you, Your Honor. And lastly,
so this is go to prison without trial, by the way, right? Was there trial for them?
Until the end of their sentence. Is that means it will be a trial for these detainees.
No, but so there hasn't been a trial. They're offered this choice, either go and work and not get paid, by the way, or go to prison until the end of your sentence. That's not much of a choice, is it?
We would say that the reduced 2 months detention is a remuneration, and the remuneration must be the money. And go. And
I'm listening.
Yeah, thank you, Your Honor. And we will say that before they go to the sanctuary, before they go to the educational camps, the condition at the sanctuary, the condition of the educational camps didn't influence their choice. So they have the choice to go to the educational camp or go to the prison. So this may be the point, if I may proceed. Thank you. And lastly, the duration of the detention was not uncertain in our case. According to the press release of Ministry of Interior, the arrested terrorists will be sent to the educational camp for 15 months. And in Canada case, it was pointed out that the element of the crime, the duration of the detention was not the element of the crime of enslavement, but one of the elements to determine the quality between the accused and the victims. Therefore, based on the content, there was no ownership relationship between them. The BNS was not the owner of the detainees, but as a helper to help them to reintegrate into the society. In conclusion, we submit that the court has no subject matter jurisdiction over the case, since neither the contextual nor the specific element of crime against the humanity according to Article 7 of enslavement according to Article 7 Rome Statute are fulfilled. If your honors has no further questions, my co-counsel will address the last 3 issues. Thank you.
So maybe because we have a little bit of time, let me just ask my my brothers and sister on the bench if they maybe don't have a question. But no, they don't. Okay. Thank you very much, counsel.
Thank you.
May it please the court, I will continue the defense's argument. The defense submits that the case is inadmissible. This court is a court of last resort, which is subject to the complementarity principle under Article 1 of the Rome Statute. The court is not allowed to try people who have already been tried for the same conduct by domestic courts as stated in Article 17(1)(c) of the Rome Statute. The general rule here is that the defendant before this court must have been the same person who stood trial for the same crimes before the domestic courts as was stated in a Kenyatta case. This is
counsel, so I'm sure you knew this question was coming, so let's just get it out the way. But there wasn't a trial, was there?
I will address that point in a second.
Okay.
First, let's get to the general rule. Is the defendant the same person? Clearly he is. Lord Blaze has been subject to domestic proceedings under law number 14, which confirmed his amnesty on August 27, 2019, and they concerned the same crimes. The test is, for the test, it is irrelevant whether the crime was framed as a crime against humanity of enslavement, because the test is merely whether the conduct in question is substantially the same as stated in a Kenyatta case. Since the amnesty concerned all his actions in Black Mount, it also concerned the alleged crime of humanity against enslavement, and therefore satisfies this general test. Furthermore, the judgments which can satisfy the Article 17(1)(c) rule also need to be of res judicata effect. Now, the court has previously stated in the Gaddafi case that res judicata effect is associated degree. The court only referred to convictions and acquittals, but amnesties should similarly suffice since they are equally final, since there is no further way of then pursuing the case after an amnesty. Now, there is, however, an exception to the rule in Article 71C, which is Article 23 of the Rome Statute, which is if the proceedings were to shield Lord Blaze. However, the proceedings were not, and they were a genuine trial, which we can see in the rules of Law 14.
Counsel, I'm not sure. Yeah, I'm not sure if you're answering that first question that I asked you, because I can hear you're talking about it generally, but for me, this is a fundamental issue.
I am now addressing it because under law number, under law number 14, it had to be a trial because judicial control wasn't present just for granting an amnesty once an apology has been given. Judicial control was actually present for determining whether the apology covered all the relevant conduct. So there was an actual judicial investigation, and there was a possibility of criminal sanctions, because if his apology hadn't covered all the relevant conduct, he could have been subject to criminal sanctions. So it is similarly to a trial.
Pause there. So if his apology didn't cover all the relevant elements, he would have been subject to a sentence for what?
He would have then had to stand
trial.
Another subject to another, under which then another trial. Then another legal provision would have basically come into place, and then he would have faced under that he then would have been convicted for everything instead of having the possibility of being given an amnesty.
All right, counsel,
however,
so the problem,
Lord Blaze
so the problem is that in answering that critical question, your connection got, so I actually didn't quite hear the answer. And now you've frozen.
Can you hear me now, Your Honor?
Yes, yes,
Can
but
you
I
hear
see
me now, Your Honor?
Yes, but I see your connection is bad, but try. Let's try it. Yeah.
The argument is that under law number 14, if his apology had not covered everything, he then would have been convicted for all his crimes instead of having the possibility of being granted an amnesty. Therefore, criminal sanctions were a possibility.
So pause there. So he makes an apology. The court decides the apology is not sufficient. Would that be enough to send him to prison for commission of crimes against humanity?
There then would have to be a further investigation into all the different crimes he actually committed. But yes, then he would have been sent to prison, as he no longer would have had the availability of an amnesty under Article 14, under law number 14. However, he did receive an amnesty in the proceedings, similarly enough to a trial.
Okay, counsel, I'm going to ask you to pause. This is the critical question. So, if his apology hadn't been accepted, he would have had to, there would have to be a new process, new investigation, and then a trial to find him guilty and then sentence him, right?
It would have had to be a second trial.
Okay, thank you.
So since Blaze has already for his conduct, the general rule in Article 17(1)(c) applies, and Article 23 of the Rome Statute could potentially be an exception, which is if the proceedings were to shield him. However, law number 14 is the law on national reconciliation, which already tells us the purpose was not to shield Lord Blaze from criminal proceedings, rather it was to allow society to heal and to prevent finger pointing, which is a natural element of criminal trials. Instead, the law was aiming at encouraging honest admissions and apologies and giving society a chance to heal. Furthermore, even if this court finds the case admissible, the defense submits that the case should not proceed because it does not serve the interest of justice. The trial chamber has previously held in the situation in the Islamic Republic of Afghanistan that the interests of justice are not a relevant consideration at this stage. However, the case in the Afghanistan case was one which was an investigation proprio motu. Here we have a referral from a state, and that's why the defense argues that the judgment of the Afghanistan case should be distinguished. After all, in state referrals, it is important that this court does not allow itself to become a playfield for states to bring cases that aren't in the interest of justice to settle a score with other states. And here, the investigation is not in the interest of the victims, although generally the interest of the victims will favor prosecution, as stated in a 2007 policy paper on the interests of justice by the Office of the Prosecutor. This is not the case here. Research has shown, such as, for example, by Pork in the International Organization Journal in 2017, that this court's involvement makes conflict termination less probable where the probability of domestic punishment is low. Your Honors, here, the probability of domestic punishment is zero because Lord Blaise has received an amnesty. And it can hardly be said to be in the interest of the victims to allow conflict to continue and potentially claim further victims. It is in the interest of the victims to give them peace, to allow them to live in a peaceful state and not to flare up the conflict once again. And lastly, the defense admits that there are no reasonable grounds for Article 28B Rome Statute liability for Lord Blaise. Article 28B has a 5-limb test. Firstly, the superior needs to have effective authority or control over the relevant subordinates. Secondly, the superior must have known or consciously disregarded knowledge that the subordinates had or would commit the underlying offense. Thirdly, the activities which constituted the underlying offense must have been within his effective responsibility, and he must have failed to take necessary and reasonable steps to prevent or punish the subordinates. And lastly, this must have caused the underlying offense. Your Honours, the test for Article 28B liability fails on the first 2 limbs. Firstly, Lord Blaise was not an actual effective authority over the relevant subordinates, which are the BNS officers. He did have de jure authority over them, that is true. However, as stated in the Bemba case, this is only one indicum, and he actually lacked effective authority because that was enjoyed by the Minister of Interior. We can see that as there was a very weak chain of command. Lord Blaise was not actually informed of everything that happened. There was a very poor telephone connection.
Counsel?
I could hardly hear him.
It seems your time is up, so if you could just round off, and by round off, I mean no more than 2 sentences.
And he also did not know what actually happened in Centuric, as the Minister of Interior did not fully inform him of everything, as we can see in the exhibit of the telephone connection. And this shows that he, as a superior, did not have effective authority and did not know or consciously disregard evidence of the alleged crime. Therefore, Lord Blaise cannot be said to fulfill the elements of Article 28B criminal liability.
I thank you very much, counsel. Thank you very much. Counsel for prosecution, do you want to exercise your right of rebuttal?
May it please the court. Yes, Mr.
Yes, it
President.
does.
Before beginning the rebuttals, the prosecution would like to clarify on a question asked by the bench in regards to the preamble of the Rome Statute, suggesting that national amnesties go contrary to what the statute says, which at paragraph 4 says, the state parties affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. Furthermore, on the defense counsel's submission that these individuals were not civilians, the ICTY Prosecutor versus Cordish trial judgment of paragraph 643 states that crimes against humanity do not only mean crimes committed against civilians in the strict sense of the term, but also includes crimes against 2 categories of people. Firstly, those who were members of a resistance movement, and secondly, former combatants who were no longer taking an active part in hostilities when the crimes were committed. And it follows, Your Excellencies, that the specific situation of the victim at the moment these crimes were committed, rather than his status at the time of the arrest, must be crucially considered in determining his standing as a civilian. Your Excellencies, the attack of enslavement against 40,000 people occurred within the detention centers, and when it was a time when these civilians no longer posed a threat and were rather arbitrarily subjected to 15 months imprisonment without a trial, which is a breach of even Article 14 of the ICCPR, amongst other grave breaches which the prosecution will delve into at trial. On the second point, the defense stated that these individuals volunteered to be part of the education campaign. However, Your Excellencies, consent is not a factor to be taken into account by this court, as even if consent was present, Prosecutor versus Konarik on paragraph 542 states that the consent or free will of the victims would, even if present, would be made impossible or irrelevant if there is abuse of power, the victim's position of vulnerability is evident, there is detention or captivity, and psychological oppression. Thirdly, Your Excellencies, now as defense counsel's engagement with the bench, it is crucial to point out that Lord Blaise's apology does not qualify as a measure of accountability for the simple reason that firstly, his apology does not fulfill the standard which has been internationally accepted. Even, for example, in the situation in South Africa, amnesty was granted only on the condition that the individual availing it disclose all facts of their crimes. However, in our present case, Lord Blaise has failed to do so. Secondly, his apology is also objectively insufficient, as he never apologized for any of his own actions and simply blamed the Minister of Interior for the crimes that were committed. With this, the prosecution rests this case. May it please the court.
I thank you very much, counsel. Sir, rebuttal by the defense team.
Thank you, Your Honor. With your permission, I will answer the first question about jurisdiction, and my co-counsel will answer the last questions. About the first question of jurisdiction, we submit that the ANG numbers are non-civilians according to Article 50, Additional Protocol 1 of Geneva Conventions, as we already addressed. And we focused on saying that the civilian population cannot securely be said to be the predominantly targeted of the attack without the numbers and the proportions. We cannot securely to say that the attack directed against the civilian population. And I will, my co-counsel will answer the last questions. Thank you.
Thank you. Thank you very much, counsel.
May it please the court, I will continue the defense's rebuttal. Firstly, on the matter of Article 17(1)(c) of the Rome Statute, my learned colleague of the prosecution has tried to argue that here the relevant conduct was not investigated by a court. However, it actually was, as a judge had to determine whether the apology covered everything. The prosecution has referred to cases in South Africa where it was necessary to disclose all facts of the case, and has argued that this is not the case here. However, under law number 14, the apology had to cover all the conduct. Otherwise, the person would have been subject to criminal sanctions. So, in fact, the elements of the South Africa cases are fulfilled by law number 14. My learned colleague of the prosecution has further referred to case law of the Inter-American Court of Human Rights, which does not allow amnesties for crimes against humanity. However, my learned colleague of the prosecution has failed to point to a relevant provision in the Rome Statute, which would ground this rule for this court. While the Inter-American Court of Human Rights judgment can be relevant for this court under Article 21, also states that the Rome Statute should be the primary source of the law for this court. And the Rome Statute does not authorize a similar rule, and therefore the judgment of the Inter-American Court of Human Rights is not relevant for this case. Furthermore, on the point of the interest of justice, the prosecution has implicitly conceded that the interests of justice are a relevant consideration at this stage, since it has argued that the interests of justice are served by this investigation and has not referred to the Afghanistan case. The prosecution has argued that the lack of punishment of the defendant puts this case in the interest of justice. These concerns are noble and admittedly very important. However, what is a concept of justice worth to the victims when they end up dead due to the conflict not being terminated? It does not help them at all. The victims need a stable life. The victims need to be able to survive. They need a stable state. And conflict termination is made less probable by this court's involvement when the probability of domestic punishment is low. And here the probability is 0. The evidence for that can be seen, for example, Porrick's research published in the International Organization Journal in 2017. Furthermore, on the liability of Lord Blaze under Article 28B of the Rome Statute, the prosecutor has failed to show that the first limb of Article 28B liability is fulfilled, which is the existence of a superior-subordinate relationship. And this relationship did simply not exist. While he had de jure authority, this is only one indicum as in the Bemba case was stated, and the actual effective authority was not enjoyed by Lord Blaze. It was enjoyed by the Minister of Interior. The Minister of Interior was the actual authority over the BNS officers. There was an elongated and indirect command chain which ultimately led to Lord Blaze, but this command chain was not a true command chain by the time it arrived at Lord Blaze. It was broken. Azilla was the primary authority. We can see it in Exhibit 1, where Azilla tells Lord Blaze what actually needs to be done, because Lord Blaze is not even aware of the actual things that are happening in Centuric. And it took 1 week for the simple order of the 21st of September 2018 to be made by Lord Blaze. This order is so simple in nature, yet it took 1 week for this command chain to produce it. That shows that Lord Blaze could hardly be said to be the actual authority on the ground, because if it takes so long for him to make such a simple order, he cannot be the effective authority on the ground. And the chain of command was further weakened by a bad telephone connection, which did not allow Lord Blaze to even fully understand everything that Azilla was reporting, as we can see in Exhibit 1. The prosecution has further argued that the Lord Blaze has known or more has consciously disregarded the knowledge that the subordinates had or would commit the underlying offence. However, there's actually no evidence that Lord Blaze knew of it. He believed the descriptions of the Minister of Interior, as was also stated in his apology. And in Exhibit 1, we can see that the Minister of Interior only informed him of capacity concerns. And also the footage of journalists of human rights would not have put him on notice, because Snowflake Automobile actually investigated whether there was any enslavement, and strict English found that it's not. This includes the rebuttal of the defense.
Thank you very much. We have listened very carefully to your arguments, and we shall now retire to deliberate on this. Court is adjourned.
I would just like to notify everybody that the teams will be sent into separate breakout rooms and then called back to the courtroom.
Okay. Okay, so are the teams here with us? Very good. I'm going to hand over now very quickly to my colleagues on the bench to give you some comments. But before I do, I just want to say to both teams that I thought you were excellent, well prepared, and I wish you all the best. It was really, really enjoyable. So thank you very much for that. So Alice, do you want to take the floor?
Yes, thank you. Well, good morning, councils. I would like just to add a few words to congratulate your both presentations were very well done. You were both teams very well prepared. You knew the facts and the law. It was very clear. You could jump back and forth with the facts law, even if there were questions, quite a few questions from the bench. You didn't lose your composure, which is commendable. Under circumstances in the courtroom, it is extremely it is extremely stressful to be under time pressure, having to cover all your arguments, and certainly having to understand what the bench wants to hear. So you did both teams a very, very good job on that. The prosecution, I think that's my observations. At the beginning was struggling a bit with the questions, but then was quickly able to catch up and pause, think, and then address what the issues from the bench were. So that also is an indication of very good skills on your feet. As for the defense, I commend your bravery, because the facts of the case are not very favorable to you. So the way in which you presented them, for me, they were very articulate, persuasive, and you handle the questions with grace, even if you were sticking to your own arguments. So I did not get the impression that you didn't want to answer the question from the bench. I had the impression that your facts were very difficult to handle, but you didn't get flustered. You kept very, very well concentrated and focused. So I think that was your strength. If I had to give you a comment or something further to reflect, in terms of speaking in public, I would just try to slow down. I understand you have many issues and topics to cover, and you wanted to cover them all, but in real life, you would have made probably written submissions, and the hearing was just to address the few outstanding, more complex topics or issues that the bench had identified. So I would try to identify prior to going to court, what are your main arguments, and focus your submissions on those arguments, and taking the bench slowly through your arguments, because there were many packed in a very, very limited time. And sometimes we understand that you have to go fast and speak very fast. But in speaking fast, sometimes the listener is lost, and then it's difficult to catch up again with your arguments. So that would be generally the comments that I would like to put forward for you to further consider.
Hey, Judge Kazushige, you want to take the floor?
Yeah, thank you. Just I will add one point. Yeah, because individual points were explained very in detail, so by Judge Zago, sorry, and that's why I will celebrate both teams, particularly for struggling with the difficult and many questions. So from the bench, I think yeah, actually your challenge was yeah, excellent. I think so. Yeah, thank you.
Thank you very much. So I just want to add one thing, actually just one or two things. One is when you're receiving many questions from the bench, my experience, both from my time when I used to do moot courts as a student and from the many times when I've been on this side of the bench, is that questions only go to participants who are performing well. Judges are human beings, and if they can see that you're struggling, that they don't ask you questions, they don't ask you too many questions. So if you see lots of questions from the bench, that must fill you with pride. It means that you're doing a good job. And I think both teams, the reason why you received a lot of questions from me is I believe that you could handle them. You gave me, so that's one thing that so that you should take from this. The second thing is just to emphasize the point that Alice made about time. We know that we interrupt you. If you run out of time, we're not going to hold it against you. So we're not judging who won the case, right? So if you run out of time, we're not going to say, well, she didn't address point number 3, so the prosecution loses. No. So go through your arguments deliberately, respond to the questions. Ultimately, that's the most important thing. So again, congratulations to both of you. I thought it was excellent. I thought that you handled the really difficult, tough questions well. So my responsibility now is to announce the winning team. But before that, let me just say that I think you are both winners. Both teams are winners. And I'm not saying that only because it's a line. I'm saying that because I really was impressed by the way you argued. It was a very difficult deliberation, so it was very close. We went back and forth. And I think because it was so close, it took us longer than we would have so normally done. But having said all of that, at the end, we have come to the decision that the team for the prosecution has won this round, and so we wish you the best in moving forward. But we also congratulate the team for the defense for excellent presentation. With that, I think I'm entitled to say now the court is adjourned. Court is adjourned, and goodbye, everyone.